A very good afternoon to everyone present. Thank you for joining us for today's online talk, which will be starting shortly at 3 p.m. For those of you who are early here, thank you for waiting patiently. While waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on a bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationship with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
The firm invests in its team and emphasizes professional development. We are keen to share our knowledge and publish our articles on our website. And we also give back with our corporate social responsibility activities. We cultivate a passion for the law and enjoy what we do. This brings out the best in us for our clients today and tomorrow.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining today's online talk entitled Serious Professional Misconduct in MMC Disciplinary Inquiries. My name is Kirthika Padmanapan. I'm a pupil in Chambers with Mohd Associates, and I will be your moderator for today's session. Before we start today's talk, let me introduce the firm and what we do. Mohd Associates is a mid-sized law firm that was founded in 1985 by Dato' Mohd Quai. Our able team today comprises of 28 lawyers and a support team of 21. Dato' Mohd is today a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with SMEs, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, including litigation, arbitration, and adjudication, a dedicated industrial law relations and employment team, and a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWKA online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, which have also been broadcasted live. But with the COVID-19 MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. Before I continue, please be reminded that this talk does not constitute legal advice. In the event that you require specific legal advice to your matter, please contact us for a complimentary legal consultation. Details will be given at the end of this talk. Our speakers today are Jasmine Wong and Anis Muhammad Sohaimi. Allow me to introduce Jasmine and Anis. Jasmine is a senior associate in our Dispute Resolution, Employment Law and Industrial Relations Department and Individuals and Families Departments. Her areas of practice include citizenship, adoption, medical malpractice and negligence, and employment law. She is also a contributor to the Personal Injuries Chapter in the LexisNexis Atkins Court Forms Malaysia and is a member of the Medical Legal Society of Malaysia. Anis is an associate in our Dispute Resolution, Individuals and Families and Corporate Departments. She's also completed her Bachelor of Laws from International Islamic University in Malaysia and was subsequently admitted to the Malaysian Bar in 2018. Her areas of practice include general litigation, Sharia estate planning, professional malpractice, criminal defense, and corporate advisory. We will also be having a Q&A session at the end of the talk, so please post your questions into the Q&A chat box at the bottom of your screen. The talk points for today are the role of the Malaysian Medical Council, proceedings in an MMC disciplinary inquiry, what is serious professional misconduct, and possible outcomes and punishments. The first 2 points will be addressed by Jasmine, and the latter 2 points will be addressed by Anis. I will now pass over the time to Jasmine. Over to you, Jasmine.
Thank you very much, Kirthika. Hi, everyone. Welcome and thank you for spending your time here with us today. So I'll begin the talk on the Malaysian Medical Council, or usually known as the MMC. A little background on the MMC is that it was actually established by an Act of Parliament under the Medical Act in 1971. This is actually in line with the aim to provide safe and competent healthcare services for the country. And their statutory responsibility would actually be to register medical practitioners, to regulate the practice of medicine generally. But more importantly, it is also to regulate the competency of the registered doctors practicing in Malaysia. Their motto, as you can see here on the screen, is safeguarding patients and guiding doctors. Now, in monitoring the standards of the practitioners, MMC is actually empowered to exercise disciplinary jurisdiction over any registered person who has committed, the phrase here is serious professional misconduct. Now, I have highlighted the words over any registered person because MMC doesn't hear all complaints. They will only address complaints against registered medical practitioners. So they have no jurisdiction over, say, hospitals or nurses. The key here also is disciplinary jurisdiction. So this is only on matters regarding disciplinary breaches done by the medical practitioners. Under the MMC proceedings as well, MMC doesn't go into issues of negligence. And as such, they have no power to make monetary awards or compensation in any kind. This is one of the common questions that we have addressed to us most of the time, because when patients or complainants come to us, they want to know what can they get out of this MMC disciplinary inquiry. But this is essentially a disciplinary process meant to regulate doctors. How does a registered medical practitioner actually commit a serious professional misconduct? It would involve the practitioner breaching the MMC's Code of Professional Conduct or any ethical code or guidelines endorsed by the MMC. Now, this Code of Professional Conduct details out several minimum standards, which include a doctor neglecting or disregarding his professional responsibility, abusing professional privileges and skills, conducting himself in a manner which would, say, tarnish the reputation of the profession, or perhaps even self-advertising. This would be covered in further details by my colleague Anis in the second half of our talk. Essentially, any medical practitioner should be mindful of good medical practice. This is actually a guideline provided by the MMC. And if the practitioner breaches any of these principles or guidelines, it may result to a complaint filed to the MMC against them. As you can see here on the screen, I have actually listed down quite a few of good medical practice which should be adopted by medical practitioners in their profession. And these are quite a number of guidelines endorsed by the MMC as well. As you can see, it would include guidelines for house officers and what they can or cannot do or should not do. Medical practice guidelines for senior medical practitioners. MMC have also covered quite extensively on who can be expert witness and what their duties are. And as you can see here, the list goes on, but this is essentially the guidelines provided by the MMC. And all doctors and practitioners should be well versed with these guidelines. So again, coming back to this, what are the procedures in an MMC inquiry? As you can see here from the flow chart, there are quite a few steps in an inquiry. We start off with the complaint filed, and then it would be moving on to the Complaints Management Committee, next to the Preliminary Investigation Committee, moving on to the Disciplinary Board, coming to the Medical Council, and the last stage, we would stop at the appeal of the High Court. I would go further details into it. So when a complainant or a patient actually is dissatisfied, or they are of the opinion that the doctor, the medical practitioner has done any ethical breach, this is the first step for anybody. You get the complaint form from the MMC's website. It's very easily accessible. It's quite a simple form as well. It has details of the complainants. It will ask you for details of the registered medical practitioner whom you want to complain against. You are required also to put in the nature of your complaint. What is your grievance? What are you dissatisfied about? And if you have any supporting documents, you put it in. They would also ask you if you have any witnesses to support your complaint. If you do, then you would be able to submit the details of the witnesses in this form as well. Now, the importance about this complaint form is that the complainant's identity will need to be identified. You cannot lodge a complaint to MMC anonymously. Because if you don't give your name, that would be one of the reasons for MMC to not entertain your complaint. So when we come after receiving the complaint, the Complaints Management Committee will actually scrutinize all the received complaints. They will first of all ensure that the complaint, they are in writing and they are against a registered medical practitioner. So like I said, if you lodge a complaint against a hospital or a nurse, your complaint will be thrown out. You will be informed that they will not be entertaining your complaint because they have no jurisdiction over it. So after receiving the complaint, the Preliminary Investigation Committee, the PIC, they would, as the name suggests, they would conduct a preliminary investigation on whether or not they should be having an inquiry. And like I said just now, the identity of the complainant is important because if it is unknown, that will give the PIC a reason to just dismiss and not entertain your complaint. Or if at this stage, the PIC discovers that your complaint has elements of negligence and they don't actually involve disciplinary matters, that is another ground to dismiss the complaint summarily as well. And if for some reason PIC thinks that your complaint was fabricated or it is false, also it will be dismissed. Once they have received the complaint, they would share the complaint with the registered medical practitioner in charge within 30 days. And they will also ask the practitioner to provide a written response within 30 days as well. Once the practitioner has provided his reply or clarification, this PIC would recommend to either dismiss the complaint for whatever reasons that they think is appropriate, or if they think that there are merits to the complainant's complaint, they will forward this complaint to the disciplinary board for the next step to have an inquiry. And like I said, if upon notifying the practitioner about the complaint, and if the practitioner decides to disregard the complaint and not do anything about it, the PIC would recommend for the inquiry to be continued as well in the absence of the response. And whatever decision that the PIC makes, the complainant will be informed of the decision in writing. Now, one of the new powers under the new amendment in the Medical Act is that the disciplinary board will be able to, before the conclusion of the inquiry by the disciplinary board actually, they would be able to issue an interim order if it is necessary for the protection of the public, or if they think that it is in the interest of the public or the practitioner. This interim order could be a suspend the doctor from practicing, or restrict the doctor's practice up to a duration of 6 months. And it can even be extended even further to 6 months. During this time, during the suspension, the doctor would be regarded as if he does not have the license to practice, but the name would still be in the register. So if you were to conduct a check on the doctor, his name would still appear on the register. This interim order will be reviewed after 6 months, and there are durations for them to review the interim order to see whether or not it would cease to have effect, or there are any grounds to extend the order. And if the practitioner is not happy with this interim order, they will be able to appeal to the Minister of Health. And whatever decision that is being rendered by the minister, it will be final and binding. So when the complaint reaches the disciplinary board, what they would do is they would invite and inform the complainant and about this inquiry. They would set a date, a venue, and a time, and get both complainant and the doctor to be present during the inquiry. During the first hearing, the complainant will present his or her complaint, telling the disciplinary board what are the issues and what are her grievances and complaints. After presenting the complaint, the disciplinary board would be able to examine, will be able to ask questions, and the same thing goes for the doctor as well. Doctor will be able to ask questions to the complainant. The questions could be anything relating to the complaint. The same process goes for the complainant's witnesses. So most of the time, from what we have seen, is the complainant would bring witnesses such as their spouse or their parents who were present in the consultation room, and they will be able to testify that this is what happened, or this and that was said by the doctor and what has happened. So the witnesses would be subjected to the same process as well. They will be asked questions on whatever that they testified. And this presentation of the complaint is important because it will be the determining factor on whether or not the board thinks that they need to proceed to the next stage, or they just end the matter there and there. Like I said, after they have evaluated the complaint, the board may recommend that no further action be taken because they think that the complaint has no merits. Or if they do, if the merits are present, they will frame the charge against the doctor. At this stage, the medical practitioner would already be known as the respondent in this case. The respondent would then be informed of the charge, and he will be required to enter his defense. And same thing as well, he will be given the opportunity to call witnesses to support his defense. And if it is also necessary, the medical practitioner will be able to call expert witnesses in support of his defense. Not anybody can be experts in such a matter. They will actually need to have the appropriate expertise and experience in the particular field that the doctor is practicing. They must be also familiar with the duties of the expert. So just because the doctor is calling an expert, it doesn't mean that the expert must be saying yes to everything that the doctor is saying. They must act independently and provide their honest opinion on the subject matter. During the course of the inquiry as well, if the disciplinary board is of the opinion that the doctor is professionally incompetent or his fitness to practice is impaired by any physical or mental disability, the Act provides that the board will be able to refer the doctor to a fitness of practice committee for an evaluation. And as the proceedings go, after the doctor has entered his defense and called any witnesses or provide supporting documents in support of his defense, the board, same thing, they will be able to recommend that no action be taken, or if the board thinks that there are grounds to justify the charge, then they will inform the doctor of their findings and decision and invite the doctors to enter a plea in mitigation. So doctors would be required to try and mitigate their circumstances so that it would it would bring a reduced punishment later on. The common one would be that it was not intentional, or it's the first time of them committing that kind of conduct. These are the common ones that we usually hear about. And after hearing the plea in mitigation, the board will recommend a punishment to the council. Now, ultimately, the board only have the powers to recommend any punishment, and the decision will eventually lies with the council. Another point to note is that in making the recommendation, the board will also be guided by the principle of proportionality. So what it means is that whatever punishment that the board recommends, it must be proportionate to the gravity of the misconduct. So if, for example, if a doctor breached one of the ethical code for refusing to speak to a patient, the board would need to recommend a proportionate punishment. So it would be perhaps a fine or a warning, instead of recommending the council to strike off the doctor entirely from the role. So that would not be proportionate. And after perusing all the evidence and the recommendation from the board, the council would be permitted to make this kind of decisions. They can either accept the recommendations and impose the recommended punishment, or if they're not satisfied with what they have read in the records or the evidence that was presented to them, the council would be able to direct the board to reconvene the inquiry and ask further questions of the complaint or from the defendant or from the respondent. If the council thinks that the charge should be dismissed, that is within their powers as well. That will also include the council rejecting the board's recommendation and make its own decision. And whatever decision that the council make, the council has the right to publish in the media the conclusion of findings after the inquiry. Now, previously, any punishment that was generally given out by the council, it would only be published on the council's website, but not anymore. Now they can publish in the media. And these are the range of punishments that the council would have. They can order the medical practitioner to be struck off from the register, or they can order for a suspension for any period that they think it would be suitable. They can reprimand the practitioner or impose a fine. And if the medical practitioner is dissatisfied with whatever decision that was given out by the council, they have the right to appeal to the High Court. But bearing in mind, any medical practitioner will be subjected to the limitation period of 1 month from the day of the decision. So if they exceeded the 1 month, it is unlikely that their appeal will be heard in the High Court. Under the appeal process, the High Court will be able to affirm the order that was given by the council. They can reverse or vary the order, or same thing, they can give any other appropriate order which is suitable in their case. Just another point to note is that in the old act, last time there was only one tier of process to the High Court, and whatever decision that was given by the High Court, it would be considered as final. But under the new amendments, it would appear that if the doctor is dissatisfied with the decision of the High Court as well, they can also appeal to the next level to the Court of Appeal. So I will now pass it on to my colleague Anis to give several examples on what actually constitutes serious professional misconduct. Over to you, Anis.
Thanks, Jasmine. All right, good afternoon, everyone. Thanks for joining us and staying with us until this point. I think this topic is quite a good topic to listen to before the Raya break. I don't know about everyone else, but most of my trips to the doctors always seem to be after Raya celebration. So thanks, Jasmine, for taking us through the procedure and the role of the MMC. Before you even get to that, the question is, what instances would you be facing this MMC inquiry? So you can either be, on the one hand, a doctor who just wants to know like the standards and basically how they can keep up and make sure that their practice is within the standards, or you could also be a patient who's maybe had a bad experience recently, or just an experience and they've wondered what can be done, or maybe they wanted to know how is there any way they can stop this from happening to anyone else. So some of these examples will be made clear after we consider what is a serious professional misconduct. So why we need to know this is because you need to know the disciplinary jurisdiction of the council. So Jasmine said it has to be distinguished between an act of negligence and an act of that requires disciplinary jurisdiction. So actually the disciplinary jurisdiction of the council covers many areas such as conviction. Say, for example, if a doctor has been convicted and whether his qualifications, studies or whatever has been withdrawn, or his registration as a registered medical practitioner has been cancelled because it was obtained by fraud. So there are many other examples, but those are quite straightforward, because when conviction is when they've been called to court and they've been convicted of an offense, and qualification withdrawn is, for example, like documents, and fraud, obviously, when they've lied on their application. So our talk today will be focused on section 29, paragraph 2b, which covers this. You will see this term, serious professional misconduct, because what constitute a serious professional misconduct, it's actually very wide and really no exhaustive list, but the council has provided code of professional conduct and guidelines and good practices, which Jasmine touched on earlier. So our focus would be serious professional conduct and looking towards the code of professional conduct. So I'll be referring to this CPC, I'll call it, and the examples that he has set out. I mentioned that it's in force from 23rd February in 2021. This shows that the code is forever changing, because as time progresses, there are more acts that come up, more instances where the MMC has found that the doctors have been abusing their privileges. And so throughout time, this CPC will be revised. And so as of now, the recent one was done in 2019. So serious professional misconduct has been defined in the CPC as a failure to meet the minimum standards required of a medical practitioner. And the CPC itself has relied on this case, which has tried to define serious professional misconduct. And this case revolved around, actually, it was a doctor, the position of a director of a hospital, purely administrative functions at that time already. But at his hospital, there was an excessive case number of infant mortality. So lots of children were dying, but he failed to act upon this because he would have information about this increasing mortality rate in infants that were undergoing certain procedures. And he had taken no steps to investigate or question why these instances were happening. So on that occasion, the council, this was a case in the United Kingdom where it was considered whether the director of that hospital was considered having breached the minimum standards. So in that case, the court had defined that misconduct, basically, it's so wide, it can refer to anything, but what amounts to a disciplinary action is when it's involved in profession. So for example, it has to be something that the doctor has supposed to be, you cannot hold liable any layman who wouldn't know or realize all these mortalities and such. And serious, it's basically, there's no like restrictive definition, but anything you will see in the examples, how it can be something very small and something we think is insignificant and we've probably faced before, but we've never really taken action, to something more severe, preventing the death of a baby. So the CPC has basically divided the examples of serious professional conduct into these four main headings. So the first one, neglect or disregard of professional responsibilities, it's generally towards the relationship between a patient and a doctor. It would be how they would greet you, how they listen to you. It's all the sensitive parts of human interaction. And abuse of professional privileges are solely for misconducts which only a doctor could have because of their privilege. For example, a doctor has access to drugs, to medicine. They've abused this access and either taken it for themselves or have given it and distributed to those who are not entitled to. So those cover those types of conducts. And under the third heading, it's conduct derogatory to the reputation of the medical profession. So this is generally you'll see the more severe examples. And it generally means anything, basically the profession of a doctor is to protect life. So anything that a doctor does to threaten this, like torture or intoxication, anything that affects the health of a person would fall under this heading of a misconduct. And then there's just a miscellaneous heading where it covers the general activities in a clinic, so like advertising, canvassing, and related professional offences. So we'll go into these headings one by one, and the code covers quite a lot of examples. So I've just taken a few examples that you may have come across, or like the more interesting examples. So under the first heading on disregard of professional responsibilities includes maintaining good standard of medical care, including conscientious assessment. So this would cover when you go to a doctor, you would want the doctor to give her full attention to you. I think we've always discussed how sometimes we fear going to a doctor because we feel like we're dying, but then the doctors go take a nap. The duties of a doctor cover that they have, because when we go to a doctor, we're sharing such sensitive information that we don't share to anyone else. And because they have that access, they really have to guard this relationship and trust that we give to them, because especially our bodies, our health, it's very, very important to us. And when we go to them, they need to be sensitive about this and they cannot make us feel like, what did I just do here? And then the next example is that you have a responsibility to ensure that the organization that you work for has adequate facilities. As a doctor, you have to make sure that if you're working at a clinic or any hospital, you have to make sure that the facilities there are proper, and if they're not, you have the responsibility to report it or to make things better. So if you've ever gone to seek for treatment in the back alley, I hope you haven't. So that's something that shouldn't be done, but surprisingly, it's not unheard of. And then another example is you cannot endanger the welfare of a patient in an area that you're not knowledgeable in. You will see this manifested, for example, when you have an issue, you may have a problem, you have a pain in your stomach, and then after examination, the general practitioner will say that he needs to make a referral because he's not really sure. So this is them ensuring that they comply with this, to say that they're not familiar with this area and they need you to go to a specialist or someone who knows that part of the body, so they're not abusing their professional responsibility. Next is allow for request for consultation. So on the one hand, a doctor has the duty to refer it to a colleague that is more knowledgeable and has the most appropriate experience, but a patient has the right to request to see someone else. If you feel like maybe you've done your research and you found out this person has more knowledge in this operation or this type of injury or disease, you can ask the doctor to refer you to that consultant. And then you need to make sure that obtain valid consent, ensure information is protected from disclosure. These are the very minimal standards that you expect always. And for example, like protecting the life and health of a person who's being researched on. Although your main intention may want to work towards the improvement of medicine and find life-changing cures, you still have to make sure that when you do this, the patient's life is protected. So that's why when you see people signing up for these kind of programs, they always have the right to opt out anytime, because it's their choice and it's the responsibility of the doctor to make sure that they feel like their life is in good hands. These are just more examples, but I've highlighted this because, as I mentioned earlier, the CPC continues to change and include more instances of misconduct. So these are some of the examples which were recently added in the 2019 version of the CPC. So now I've taken out some of the examples, so you can see the doctor has to make sure that he should not prescribe traditional medications, which I thought it was surprising because you hear these conflicts in the news, but you don't think it's part of the CPC. And then there's an example of end-of-life professional management. So this is where Malaysia varies, because this position that each country takes towards euthanasia or mercy killing, as you may know. In some countries, they allow it, but in Malaysia, the standard is that it's not allowed. So that's where you see the restriction in paragraph 1.114 of the CPC. Next, misconducts which come under the second heading, which is abuse of professional privilege. So these are things I've highlighted the additions from the latest CPC, but you can see how, for example, medical certificate, the MC, it's only something that a doctor can issue. So they have guidelines that they have to follow. And yeah, so they have to make sure that when they issue these documents, it has to be based after a proper examination, and it can't be just giving them out. An example I took here was chaperoning. So you wonder, what does it mean to chaperone in terms of the medical profession? So here the code has set out that basically it's the practice of when you're examining someone of the opposite sex, you should have someone who's around, or as a patient, you can request for the same gender of doctor to be assessing you. So this is to protect the dignity of the person. And also it's a privilege because obviously there's no other profession where the different gender can have an inspection. Like even when you go through customs or anything, it's always a male checking a male, female checking a female. So this is a privilege that applies to the doctors and patients situation. And this is a guideline and a standard that doctors have to abide by. And if they don't, patients have a right to report them for misconduct. Now we go into the examples under the third type of misconduct, which is conduct which is derogatory of the reputation. So I mentioned earlier, anything that tries to destroy life. So this includes torture, anything against humanity. So that's why you will see that medical practitioners, regardless of, for example, if they're in the middle of a war, and there could be politics involved, it could be a civil uprising or something like that. But as a doctor, regardless of which side you're on, you have a duty to treat and save the life of whoever comes before you. So this is where that type of misconduct comes under. And you have to, I think in any profession, make sure that you observe proper standards of personal behavior, the way you conduct yourself, how you carry yourself, make sure that it doesn't bring your profession into disrepute. And personal misuse of alcohol and drugs, obviously, because you are doctors who basically tell people not to do these things to damage the body, and it will be counter to your profession, and it would be an insult to your reputation as a doctor to be destroying your body. These are the examples under this type of heading. And it also includes anything to do involving with dishonesty. So the CPC also includes financial transactions such as criminal deception, forgery, fraud, and theft. So if you find any doctor doing any of these bad practices, you can report them for misconduct. And these are some examples of under the third heading as well. So you know, free splitting, meaning when you refer your patient to another doctor, consultant, you must be sure that this referral is because of the quality of care that the patient is receiving. You cannot do it because you have a prior arrangement with the other doctor to increase the fees of the patient. So these type of misconducts are outlined in the CPC as well. And you're also required to report to the higher authority if you find one of your colleagues is incompetent to practice. But the CPC has, under this heading, it has limited to like incompetence, not in terms of experience or expertise, but incompetence in terms of someone who's damaging the body, someone who's an alcoholic, someone who's always taking drugs, not for a good reason. So this is the incompetence that the misconduct relates to. And the commercial undertakings that you take, you must avoid any situation in which there is a conflict of interest with the patients. Obviously, you cannot be recommending treatments or medication because you have a stake in it. For example, you may want to recommend one type of medication over another because you get some profits if you sell this type. So that's obviously something, if you find out that it's happening, it's a misconduct that you can report to the MMC. And the last is, like I mentioned, just miscellaneous offences. It's not really so much, but I think that you would basically, for the purpose of obtaining more patients, I know you cannot make a business of people dying, so it's something similar to that. So it has these guidelines, and yeah, nothing much for this. Usually it's rare to see any misconduct under this heading. Now you've gone through the examples of CPC, we will go into the possible outcomes and punishments. To understand this, we will have to go into the disciplinary punishments, which Jasmine has already set out earlier, which includes reprimand and the registration of their practice to be subject to certain conditions. They can be suspended from practice or the name to be struck off, and imposition of fine or order of cost. So this is usually another way we distinguish when we have people come to us asking whether they can claim for medical negligence. Usually sometimes they get confused, and one question that we normally ask is, what do you want from this instance? Do you want to put the doctor on for disciplinary proceedings, or do you want to make a claim? So most of the time people want to have compensation for whatever they've suffered. So it wouldn't fall under the MMC, but it would be a claim in court. So it's only for instances if they've come to us and they said that they're not satisfied with what the doctor has done and they want to make a complaint. That comes the question of whether an MMC complaint is required. So we'll go through some of the punishments, and to understand the punishments, I've used some case examples. So you can see real life cases where the MMC has held an inquiry and they've decided on a punishment based on the severity of the misconduct. And you may agree or disagree, but that's why the appeal process is there. But you can see the type of acts that may amount to a punishment of reprimand or suspension or the name to be struck off. So an example is reprimand, and I've just listed some examples where someone has made a complaint against a doctor, and these acts have been held to be misconduct by the MMC. So an example is that the doctor refused to provide treatment and failed to provide the patient with sufficient thorough professional attention. So in this case, it was actually a elderly lady, and she came quite late at night, and she felt that she wasn't being given the full attention because the doctor was ready to leave. So she made a complaint, and the MC had heard her complaint and made a decision that the doctor should be reprimanded. So reprimand, if you're unclear, is just basically a strict warning, a stern warning to the doctor to never repeat the mistake. So this would be on the scale of punishments, one of the less severe punishments, obviously. So another example was when the doctor admonished the patient and treated the patient with disrespect and made derogatory remarks. So in that case, the MMC had decided that a reprimand was necessary. And you can also be reprimanded if you fail to issue a medical certificate. And a reprimand was also given in this case where the doctor failed to take into consideration the patient's past surgical history of fibroid operation. This lady had a history of fibroid in her womb, and basically the doctor failed to take that into consideration, and the MMC felt that it was a misconduct and required a reprimand. And another example is failure of a doctor to detect the bilateral deformities in a baby upon the routine postnatal examination. So after the child was born, maybe, for example, if there's like some traits you can notice, like for Down syndrome and any of these deformities, that a routine checkup after the baby is born. So after baby is born, the doctor will always check the usual head, eyes, mouth, nose, feet, toes, everything. So this was something that the doctor failed to pick up, and it was a routine examination, and the mother obviously complained, and the MMC found that a reprimand was necessary. And another example of a complaint, this is an example of a publication of the punishment, because the MMC does post its decisions online so you can see it. So this was an example I saw, which was an interesting example because you can see the different acts which amount to a misconduct. It can be simply by not giving someone enough attention, or also not checking a patient properly. And it could also include just sending a wrong message to the wrong person. So in this case, this doctor was sending inappropriate messages to a lady at that time who was still a patient, actually a patient who was supposed to have an operation with him. So this was a misconduct, obviously, but it was decided that the punishment would be reprimand only. These are examples of suspension for practice. So in this case, the doctor was using basically drugs. He wasn't having full control of the drugs, and psychotropic drugs are those that are like dangerous drugs and are usually under very close regulation and usually kept in a locked cupboard. So as a doctor, they need to make sure that they keep this controlled. And so the punishment for this was suspension for 1 year. So this is an example of an instance where suspension for practice was given out. And here's a similar example, also to do with drugs. So this is like an example of another wrong dealing with the drug. So this is an example of a misconduct which led to the suspension from practice. This is a more severe case punishment, which was that the doctor was struck off the register. So this is quite straightforward, and you'll notice that it's not really under section 22B for serious professional misconduct, but this is an example of where a doctor was struck off because he had produced fraudulent certificates. So basically he was not qualified. So obviously this was a correct punishment to remove him from the register, being an unqualified person. In this example, the doctor was struck off the register because he had taken, basically this is an example of where he took drugs and he was doing it under the influence. So I understand that Betadine is also a form of dangerous drugs, and obviously it cannot be self-administered, and it affects these, basically the drugs that are not allowed are like those that would impair your mental capacity. So you'll be very drowsy, you're not supposed to be practicing under the influence, and these type of drugs are also addictive and are only supposed to be prescribed by specialists and are controlled substances in the hospital. To be self-administering and using the drugs for himself is basically a misconduct which someone can make a complaint of if they've found out that such action has been happening. So here I just wanted to highlight that it's possible that whatever has been decided at MMC can be appealed. So in this case, you can see at the bottom there that it was set aside. And I guess that's all really for the example. So you can see how there's different type of misconduct, and depending on the misconduct, the punishment may be different. And sometimes you can also see the same conduct, but the different punishment is met out because there's obviously different considerations that the board or the inquiry had considered. So I think that comes to the end of my part. I'll pass the floor back to Kirthika.
Hi everyone. That concludes the presentation part of the slides. We will now be moving over to the question and answer session. The first question that we have is for Anis. During the appeal, can the appellant appear before the court without a solicitor?
The appellant can always appear without legal representation, but we always advise that legal representation is sought because then they wouldn't be well versed with the law and the procedures, and you need to prepare such documentation and everything. So lawyers would be the most appropriate people to be able to help, and they would be able to monitor like the deadline. So there's certain timelines for filing of certain documents. So it's best to get legal representation because your lawyers will deal with this for you.
Our next question is for Jasmine. What if the complaint is very obvious and the evidence is very clear, but the complainant refuses to attend the DC proceeding? What will the MMC then do? Over to you, Jasmine.
As touched on earlier, the identity or the presence of the complainant in any inquiry is quite important here. So if for some reason the complainant refuses to attend the proceeding or cannot be contacted by the the PIC at this juncture, the PIC will actually inform the council that they won't be able to proceed with the investigation, and they would be required to dismiss the complaint at that point. But there is also another provision under the Act which provides that the PIC will be able to appoint a member of the disciplinary panel from the MMC to act as the complainant in that matter. This is obviously if there are strong grounds to proceed with the complaint without a complainant. And I think you mentioned the evidence is very clear and obvious. So in such a situation, if it actually warrants that, then yes, one of the member from the panel would be able to be appointed and act as a complainant, and then they would be able to proceed with the inquiry.
Thank you, Jasmine. Our next question is for Anis. If a specialist doctor, after examining a patient with a scan, informed him that his heart is 50% blocked and is in need of an urgent operation, then the panicked patient then sought second opinion, and the second doctor informed him that his heart was normal and that there was no action required, and it was later confirmed by another specialist. Can a complaint be made against the first doctor?
Simple answer, yes. Someone can make a complaint, but whether you are held to have been committing a misconduct, it depends on the evidence presented. And actually, it's also a misconduct for a doctor to prescribe treatment that was not there. So there have been instances where the doctors had given medication and also advice for certain operations, but they were found to be liable because it was something that was not necessary. And this was after the inquiries, and it had confirmed with consulting other doctors that this suggestion by that doctor was not correct.
Thank you, Anis. Our next question is also for Anis. Is the right to publish in the media provided for in the Act?
Yes, it's provided under Regulation 40, not the Act, but the Regulation 45 of the Medical Regulation 2017. So this is something that's just been recently introduced, as Jasmine mentioned earlier.
Our next question is for Jasmine. If a complaint was to be found with no further action, would it be recorded in the doctor's record?
No, it wouldn't.
All right. The next question is, under what circumstances may a doctor remove life support?
I think that is a very, very debatable and arguable ethical issue which has been debated right since day one itself. But if we were to look into the Code of Professional Conduct, it actually provides for this situation. I believe the CPC, the conduct states that if any practitioner wants to prolong life with life support, or even to terminate life support, it's got to be made with the best professional judgment, and as well, most importantly, to consult with the medical colleagues, with their colleagues, and the next of kin, with the family. Again, it's a fine line because we need to balance out the patient's interests and also freeing up the medical resources that we have. So this would really depend on the medical evidence available and the factual circumstances. But I know for a fact that the Code of Professional Conduct actually say that the medical practitioners must not be involved with euthanasia or even assist in the patient's suicide. And again, in any event, we've also got to bear in mind that if the patient actually signs form "do not resuscitate" in that manner, then yes, the medical practitioner should follow the wishes of the patient.
Thank you, Jasmine. Our next question is for Anis. With regards to the rule of no advertising, the person asks, what about skincare clinics with the advertisements that appear everywhere in this country? Can the MMC take action without any complaint being made?
So actually, there must be a complaint. Obviously, you cannot send a complaint anonymously. But in that case, I wouldn't say that it's a breach of the CPC in that sense, because it's not advertising. In that sense, they're advertising their clinic, so the services that clinic provides. What the CPC prohibits is doctors who present themselves like, come to me, I can heal everything. So it's like that, to make a promise to say that you're a life healer, and it's advertising yourself as the medical practitioner. But in terms of clinics and hospitals, when they promote their services, they're not bound by that CPC, like Jasmine mentioned.
All right, thank you. Our next question is for Jasmine. What happens to the MMC proceedings if there is an ongoing court case?
Okay, another common question which we usually get. The short answer is both proceedings in the MMC and before the court, they can actually move simultaneously with each other, because essentially here in the MMC inquiries, what is being determined is allegations of disciplinary misconduct and whether or not the doctor has breached any ethical issues or guidelines that's provided by the MMC. As for the matters, the proceedings before the court will actually look into elements of negligence and whether or not the doctor has fallen below the standard of care. And both constitute very different elements. But I should also mention that if there is already an ongoing court case, what the preliminary investigation committee would do is they would study each cases and determine whether or not the issues raised are identical. Because I have seen several situations where the PIC would inform the complainants that because of your matter in court, we have decided to put on hold your complaint before the MMC. So such situation may arise as well. It really depends on the factual circumstances of the case and what is being alleged in the MMC inquiry and before the court proceedings.
Our next question is for Anis. This person would like to know why there are so many levels or stages in an MMC inquiry with regards to having a committee, a board, and a council.
One answer is that it's regulated in statute, so the law is there, so we follow the law. But generally, it's because each stage is for a different purpose. For example, the first stage would be to filter claims without basis. So these would be the claims where, as Jasmine gave an example, there was no complainant ID, the facts involve elements of negligence, or they do not constitute disciplinary matters, and the truth of the complaint is doubted. So it would be to filter type complaints that are made without basis, and the subsequent stage would be to assess whether the doctors have any defense and so on and so forth. So there's so many stages because each has its own separate and distinct role, and yeah, so that's why there's so many.
All right. Thank you, Jasmine and Anis, for your insights. Before we conclude, I have a few announcements to make. First of all, please join us again for our upcoming talks. Our next talk will be on the 27th of July on strata living issues, interfloor leakages and short-term rentals. You may also scan our QR code on the screen to sign up for our online talks. Second of all, please fill in the feedback form and tell us what you thought about our talk. The link to the form will be posted in our chat. Thirdly, do follow us on all of our social media accounts. We are on YouTube, Twitter, Instagram, LinkedIn, and Facebook. Fourthly, if you'd like to speak with any one of our lawyers, and if you have any further questions, we do offer a complimentary 30-minute consultation over the telephone or over a video conference. Please fill in the form on our website, and the link will be posted in the chat box, or alternatively, you can also scan the QR code which is on your screen now. To our guests, thank you for joining us. We hope you have found today's session informative and useful. Thank you, everybody, and see you at our next talk.